Hi, all. Thank you for joining us today. As you've probably recognized, I'm not Susan. Susan has strep throat today, so you get me instead, and we're going to do a little bit of um, an overview of estate planning so that when she does do her presentation about the pitfalls of not doing estate planning, you'll understand a little bit more of the documents and she doesn't have to cover those as well. So if you saw my presentation with Susan at the governor's conference, this is going to be pretty similar. So I will not be offended if you want to log off now and wait till Susan comes back. But I will try to keep this to about an hour. You're free to answer or ask questions anytime you want to. You can put them in the chat and Annalisa will stop me and read them out to me, or you can unmute yourself and ask questions as we go. So I am Katie Lovell. For those of you I've not met yet, I'm the legal services developer for the state of Montana. This is going to be a estate planning 101 session. Now, I am not an attorney. I cannot give you legal advice. So this is going to be legal information. And if we have any legal advice questions, we will write them down and have Susan answer them the next time she presents for us. Okay. What is estate plan? So this is a pretty basic question. I think we all think we know what estate planning is, and we may have a very different definition. So estate planning is arranging for the disposition and management of your estate at death using wills, trust, insurance policies, and other devices. So it can be a lot of different things for a lot of different people. It really depends on the size of your estate. It depends on who you're leaving to. It depends on what you want your legacy to be, or what you want your want your heirs to do with the estate. So let's see if I can get back here. What if you do nothing? That's a really good question. A lot of people don't want to do something for estate planning. They don't think about it in time. They pass away young, or they're just not really sure what to do. So if you do nothing in Montana, we have laws called the laws of intestacy, which just means that you've died without a will. So what happens to your estate is going to be determined by law. And it really depends on who is part of your family when you pass away. So whether or not you have a surviving spouse, whether or not you have children, whether or not those children are the children of both you and your spouse or just of you, it really has a huge impact on blended families. It has a lot of impact on whether or not you still have parents or siblings alive. MSU Extension, which is a wonderful program. I'm going to shout them out quite a few times during this presentation because Marcia Getting has done an amazing amount of work on compiling all of this information. They have a really great interactive tool that can help you go through what would happen to you if you were to pass away today without doing anything. You can also do this with clients if they are saying, I don't know if I really need a will. I don't really want to write one, because it's possible that they are absolutely fine with what would happen to their estate if the state gets to decide what happens to their estate. So there is a very important caveat in Montana, is that laws differ for Native American folks who have trust land. And trust land and the distribution of trust land is determined by the BIA, and who you can devise to and how that property is going to pass is very different from how property passes that is not held in trust. So it's very important, if you have a client who's a Native American, that they look at estate planning. It's even more so for Native American folks, so that they can preserve that trust land and let it go back to the people that they really want it to. So, but most importantly about not doing anything is you lose the right to choose. So you don't get to have a say in what happens after you pass away. You don't get to leave to charity. You don't get to leave to a favorite cousin. It's all going to be determined by the laws of the state of Montana. So you can be fine with that, and that's okay. But if you want to choose something differently, it's very important that you make that decision for yourself. So here is a really wonderful chart that is part of that Dying Without a Will Montana. Marcia Getting does such a better job explaining this than I do, and Susan can also help for this, but it really depends on your situation. So if you are married and you have only a spouse, your spouse will inherit everything. If you are married and you and your spouse have children together, then it will all go to your spouse. So it's just really important that you look at these charts, that you have some support and some guidance in making those decisions before you decide whether or not you want to write a will or a trust or any other type of estate planning. Okay, now that we've scared you a little bit, you're going to do something. So now, what is that something? So the first part of the estate planning process, and the reason we call it a process, is this isn't a task that you're going to check off your to-do list. This is something that you're going to go through in multiple steps, and you're likely going to have to repeat it more than one time in your life. So the first thing you need to do is decide what you want. And this is really important. It's not something that we often talk about in our culture. Often death is kind of seen as sort of a taboo subject, and we don't do a lot of thinking about it or talking about it. So it's really important to decide, this is what I want to happen with my estate. This is who I would want to bequeath to. These are my heirs. These are the charities that I want to support. This is what I want to happen. And then after you have that discussion with yourself, you need to talk to your friends and family. This is especially important when choosing things like the personal representative in your estate or your agents in your power of attorney. You need to make sure that people are willing and able to serve in that role, and that they're willing to honor your wishes. Very, very important. Then, after you've had those two conversations, you are going to have your documents drafted. We always suggest having them drafted by a legal professional. And the reason is these documents, while they look very simple, can be very complicated, and they can have very severe consequences if you don't do them correctly. And it's very easy to make a very simple mistake that can mess up your entire estate planning. So it's very important to have them looked over, to have them drafted by a legal professional. And there are a lot of resources in Montana, especially through our program, that can help you do that. So, taking advantage of that free services, very, very important. Then, after you draft your legal documents, you have to distribute them. It is a very common occurrence that we get folks who have come back to a legal clinic after we've been to their community 5-6 years ago, and they bring us the packet in the same envelope that we put it in when we were there last, and say, here's the documents I did last time. And they haven't taken them out of that envelope. They didn't give them to their doctors, to their financial institutions. They didn't distribute them to their agents. They're all in that envelope. If you have these documents drafted and no one knows about it, they are not any good. You have to distribute them. You have to file them. So, so important. And then after you do all of that, the best part about this process is you have to do it over again multiple times throughout your life. Not necessarily mean that you have to redraft documents, but you need to continue to have that conversation with yourself. You need to have that conversation with friends and family members at multiple times throughout your life. You need to do a periodic review. And the reason, or one of the ways that we suggest doing this, is what's called the 5 Ds, the rule of 5 Ds. So the first one is the death. If anyone in your close family or friends passes away, you need to look at how that's going to impact your estate planning. This is especially true for spouses, but it's even more true for children. There isn't much that affects a family quite so much as losing a child, and it can be incredibly difficult to redraft those documents, but also very necessary. You also need to think about, if a child passes away, do you want their spouse or their heirs to inherit, or would you want it to go back to the remainder of your surviving children? Very important. If anyone in your estate planning, including yourself, go through a divorce, that's another time to look at your estate planning documents and say, I don't want my former daughter-in-law now to be listed in my will. She's no longer a good choice for an agent. Or maybe she is, but you need to have that conversation and you need to look at those documents again. Anytime you or someone close to you receives a new diagnosis, this is especially true with memory diagnoses, anything like Alzheimer's or dementia, Parkinson's, something that can affect someone's memory. They no longer should be your agent if they have one of those conditions, because they can't take care of you at the point where they can no longer take care of themselves. So you really need to look at who can be that agent and who can make decisions for you and maybe even for them in the future. Anytime you or someone in your estate planning receives or starts to decline, and these can be very rapid declines, it can be an emergency that you get these documents redrafted. You don't want to be in a position where you no longer have an agent or your heirs, that you've messed up that line of succession. You need to look at it if there's anybody that's experiencing a decline. And then the last is a decade. So anytime you reach a new decade, you're going to make really different decisions about your estate planning at 30, at 40, at 50 than you are at 70, 80, 90. You're going to make very different decisions about your health care. You're going to make probably different decisions about who's named in your will. You may have lost friends. You may have lost family. You may have come to a different charity or nonprofit that you'd like to leave to. So it's really important that every 10 years or so, you need to look at your estate planning again. So what are the estate planning tools that you can use to make sure that your estate is taken care of the way that you want it to? So the first is a financial power of attorney. And this allows you, who is the principal, to appoint someone who would help you make decisions if you become unable to do so for yourself. And that person is called the agent. And this could include selling or buying real estate, vehicles, stocks, bonds. They can file your taxes. They can even participate in lawsuits. So if you are incapacitated because of an auto accident or an accident at work, if you don't have an agent named, your family may not be able to sue for compensation in that situation. So an agent would be able to do that for you if you needed them to. It's incredibly important to name someone that you trust in this document. This document is very important for helping you age in place and age the way you want to, but it can also be used for financial exploitation. So having someone that you trust in that position is incredibly important. We are going to go through a few scenarios, and these scenarios, I will tell you, are a little dark because I wrote them and I have a deep love for true crime, and I've been doing this work for a long time, and we see a lot of really sad stories. So I'm going to go through this scenario and then we can talk a little bit about what would happen. So George and his wife, Charlotte, are heading to see their oldest grandchild graduate from college, and they're in a car accident. They're both unconscious. They need surgery and are receiving pain medication, which makes it so that they can't make any decisions for themselves. They're transferred to a rehab center before going home. They need to pay their property taxes, and there needs to be a ramp constructed on their home before they are released from a rehab center. Neither George or Charlotte have a power of attorney because they believed the other could take care of their finances should something happen to them. What happens next? Does anybody want to drop something into the chat that they believe might be what happens next? I'm going to let you guys off the hook since this is the first scenario, but there are others. So in this situation, it would be very difficult for them to be released from the assisted living or the rehab center until that ramp can be built. So if they can't make decisions, if they can't dictate that being done, either their children are going to have to pay for it, or their children are going to have to go and get a temporary guardianship in order to be able to do that. So very, very important that George and Charlotte have made a secondary person as their agent. So it's fine to name your spouse as your agent. That's what most people do. But it's incredibly important to have a secondary person so that in a situation like this, where both you and your spouse are incapacitated, that somebody is still able to make the decision. All right, I went off that side. Okay, healthcare power of attorney. Healthcare power of attorney allows you, again, the principal, to appoint someone else who's, again, the agent, to make healthcare decisions for you if you should become incapacitated. It's incredibly important that your healthcare power of attorney is HIPAA compliant, and that means that they can have access to your medical records. And this is so important while folks move from facility to see new doctors, to see a different specialist. Without access to those medical records, it can be really impossible or very, very difficult to make sure that you get consistent care. So next scenario, Molly's mother, Anne, is living alone and recently caught her stove on fire. When Molly comes to help her mom clean up the damage, she notices spoiled food, trash, piles of unopened mail all around the house. Anne has bruises and scrapes, and she doesn't remember getting any of these, and she isn't eating or taking her medication on a regular schedule. Molly accompanies Anne to the doctor, who diagnoses Anne with dementia and says she's no longer capable of making her own decisions. Molly discusses with Anne the need to move into an assisted living facility, but Anne refuses. Anne does not have a healthcare power of attorney naming Molly or anyone else as an agent. What does Molly do next? Does anybody want to take a guess into the chat? I'll just give you guys about 30 seconds. I don't want to wait too long. Okay, so Molly would have to likely file for a guardianship in this situation, and this is incredibly sad and difficult. But yeah, Sharon's right. So if Anne has a good day, it's possible that Molly could still help her do a power of attorney. She may very well have good days, and making sure that she's getting her medication and that she's eating may increase the likelihood that she does have good days. So very good point, Sharon. She might have to file for guardianship or conservatorship. That's right. So this is the part of the presentation that Susan did when we did the governor's conference, and I'm sure she'd have more insight on all of these sides, but so you're getting the short version. But that is right. This is just a really sad situation that we see all the time, and where you can't get care for someone until you can establish that legal authority to do so. Okay. So a living will and a living will by appointment are what are called advance directives or end of life directives. And they are very specific. They say in the event that you are in your last illness or injury, that you do not want to receive treatment that will only prolong the dying process. And this is under the Montana's rights for the terminally ill. It has to be communicated formally and in writing. So this is, your very last illness or injury doesn't include, anything else that the healthcare power of attorney can. The healthcare power of attorney is much broader than the living will, which is much more specific. A living will says that your doctor can make the decision that this is the time that you're going to cease treatment. A living will by appointment allows you to appoint someone else who would say, this is the time that we're gonna stop the treatment. We're gonna stop at that situation. So really, really important document. If that's something that aligns with your wishes, it's important to do. You can actually file this with the state of Montana in our end of life registry. You can also file a healthcare power of attorney. But if these are your wishes and you want to do that living will, it can be filed in that registry. You can also indicate that you have a living will on your driver's license. So really important. So this is a scenario. At the age of 76, Frank suffers a massive stroke. He's rushed to the hospital and his family is immediately contacted. He suffered severe brain damage and has been declared brain dead. When doctors ask his 3 sons if Frank would want to be kept on a ventilator, none of them are sure what Frank's wishes would be. They haven't ever discussed the topic with Frank. What happens next? You guys did a good job answering last time, so I'm going to give you a few seconds. This is a really sad situation that we see. It's a situation that I faced with my own family a few years ago when my mother-in-law became very ill. If you don't have guidance, it's up to the family to make the decision. And like Sharon said, the doctors would look to the sons. But as a child, it can be really difficult to make that decision if you're not sure what the parent would want. So his sons would make the decision. But having that living will on file, having that guidance on file can do so much for your family to alleviate the guilt, to alleviate the pressure that they feel. And so you're really giving your heirs, your family, your friend, whoever it is that's going to make that decision, a gift by having laid out your wishes. Okay. A will and testament is a document that we use. In our program, we do very small, uncomplicated estates that are relatively straightforward. That's not true for every family. It can be very, very different. You can have a lot of things that make your estate complicated. Those are not the estates that we work with. We don't include complex trusts in our wills. We do not try to minimize federal estate tax. Federal estate tax is about $14 million right now. So if you have an estate worth more than $14 million, using a simple will is not in your best interest. Montana doesn't have estate tax, so you don't have to worry about that. A codicil, just as a definition, is an amendment to a will. So a will allow you to pass real property. You can pass personal property. You can make bequeaths to persons in your will. So friends, family members. You can also name charities in your will that will receive a portion of your estate. So really important to have a will. One of the reasons that we see the importance for a will is situations in which the laws of intestacy are not going to take care of what your wishes are. So that's what this, before we get to the scenario, a tangible personal property list is the document that's attached to your will where you can write down personal property. The reason that this is a separate document is that this document's going to change throughout your life. You may acquire a new piece of jewelry. You may have given away some of your collectibles before you pass away. So it would be things like your wedding rings, if you have a coin collection, if there's china, if you have furniture, all of those things could go on the tangible personal property list. If you decide to change that at any point in your life, you remove it, you can add another one. It's just signed and dated and attached to your will or kept with your will. You should not include cash on this, securities or CDs. Securities and CDs can have, I'm going to say they can have beneficiaries. And now that I've said that out loud, I'm not 100% convinced that that's true. I believe so. You can ask Susan to clarify that, but you should make sure that those are not included on this, on that tangible personal property list. So as a scenario, Shirley and Rob were married in 1962. Robert's daughter, Becky, was 4 years old at the time. Shirley raised Becky as one of her own, but never legally adopted her out of respect for her late mother. Shirley and Robert had 3 children together. Robert passes away in 2011 with a will that leaves everything to Shirley, and Shirley passes away in 2023. Shirley never completes a will before she passes. Because of this, Shirley and Robert's 3 children together inherit the entirety of the estate, and Becky is left out completely. How could this have been avoided? So the simple answer is that Shirley should and could have done a will. I'm sure that she would have wanted to leave something to Becky. It's very important that if this is a situation of blended families, yep. Or the other thing they could have done is an adoption of Becky. Yep. Thanks, Sharon. So really, really important that if you have a blended family, if you have stepchildren that you're going to be looking out for, that you look at how that property, how your estate is going to pass, and then make decisions based on that. Very, very important, because this can cause a lot of hurt feelings. It can cause a lot of problems for the family that nobody would have intentionally wanted. Okay. The next document that we can help you do is called a revocable transfer on death deed. And this is a legal instrument that transfers the ownership of a property. This is a good document in that it's not effective until the death of the owner. One of the things that we see in our program all the time is that someone will sign a quitclaim deed over to their child, say now they don't have to worry about probate. And then the child decides, you know what, I don't really want mom or dad living on that property. I think I'm going to sell it. And mom or dad comes to us and say, oh my gosh, my kids have kicked me out. They're selling the property. What do I do? Unfortunately, there's not a lot that folks can do. So this is a situation in which mom or dad or you retain control of the property. You can sell it. You can mortgage it. You can revoke that transfer on death deed. It's really, really helpful to families to prevent exploitation. The benefit of the transfer on death deed for your family members is that you can pass the property without it needing to go through the probate process. It has to be signed in the presence of a notary, and it has to be recorded in order to be valid. This is not necessarily a good document for every single family or every single situation. There are downsides to this document, and it's something that you should discuss with a legal professional before you decide to do it. Declaration of Homestead. A declaration of homestead is an incredibly important document. It can protect a certain value of your home against most claims of unsecured debt. So in 2021, when it was enacted at $350,000. And in the statute, it has a 4% increase in value every calendar year. So the 2023 value was $378,560 of your home's value is protected. So they can place a lien on the value above that, but that portion of your home is still protected from being able to place a lien. An unsecured debt is things like medical debt, credit card debt, if you were to be sued in an accident, things like that. It does not protect against reverse mortgages, Medicaid liens, or construction liens, or anything that you use your property as collateral anytime that you do that on a lien. And it protects only your primary residence. So if you have a home and a cabin, or a home in Montana and a home in Arizona, you can only do it on your primary resident. You can, however, do this on anything that you consider your primary residence. So if you live in a mobile home or a modular home, you can do it on that. If you live in a camper van, you can do a declaration of homestead on your camper van. So it's really a good idea for folks who are low income, especially, to make sure that they have this declaration to protect their home site. Anybody who owns a home should probably have one of these. Okay. One of the scenarios that we came up with for this is if you were to be in an accident, you total a brand new pickup. The value of that pickup is about $75,000. Montana law states that full coverage on a vehicle is $20,000 in property damage, and it has a smaller limit for medical damage as well. So if you were to hit a very expensive new truck, one of those new Escalades, one of those the Jeep Wagoneers, those things are like $110,000 brand new. You could be on the hook for quite a bit of money. So if you were to total that vehicle, you could get sued. If they get a judgment against you, they could put a lien against your house. Having that declaration of homestead can protect you against that. So protects your primary residence so you wouldn't lose that. So important. Okay. As part of the estate planning process, one of the things that we don't always talk about or don't always think about is what happens to your physical person, not just your estate, but what happens to your body. Really important conversation to have with your family, with yourself, and to put in writing. So anyone over the age of 18 can execute an affidavit or written instructions before a notary to appoint someone to control the disposition of their remains. This is really important, especially if there are folks in your family who believe that something very specific should happen to your remains, either from a cultural perspective or a religious perspective that you don't agree with. So if you want something specific to happen to your remains, it's very important that you put that in writing. If you don't put that in writing, the law has a list of who gets to take care of that. And you may or may not want that person who is next in line to be the person that makes that decision. Very, very important. We've seen, spouses make the decision that they're going to have the body cremated before parents get to see the body, to get to say goodbye to their children. So this can cause a lot of hurt feelings. It can cause a lot of hardships. And again, if you don't communicate with your family what you want, it leaves them in a moment of grief after your passing, having to make decisions for you that they're not sure what you would have wanted. And it can leave a lot of guilt, a lot of hurt for your remaining people. So it's something that you really want to make sure that you take care of ahead of time. One of the great options in Montana is the Montana Body Donation Program. You can donate your body to be used to educate health professionals. So this is how they train future doctors, future nurses. It's a really great program that allows you to provide a benefit to society after you pass away. Your identity is protected by the program, and it's run through the Montana State University. I know that you can also donate to specific universities. So, for example, I graduated from Carroll College. They also have a body donation program that you can donate through. So you can look at your alma mater. As an important reminder, there are fees sometimes associated with these body donation programs, and that can or usually includes transporting the body to the donation program if your body is more than a certain distance from the program. So it's important to look into that ahead of time and make sure that you want to do that. If you do want to do the Montana Body Donation Program, they have a really great form that you can download. It's really easy to use. They can answer questions about it, and there's a really good Mont guide about it. So you fill out the next of kin form, the brochure. There's a declaration of consent. This should be signed, and it can be kept with your will. It should also make sure that your family knows about it so that they can immediately let the hospital or the funeral home know, because a lot of times the body donation programs don't want you to be embalmed, for example, or done in a specific way. So there are situations in which the Montana Body Donation Program can't accept your remains. This is especially true if you die of it, like a communicable disease, or if your body is significantly damaged at the time of your death. So you need to have a backup plan in case that happens. I want to be buried, I want to be cremated. And often you will be or your body could be cremated after it's donated to the program. And then what happens to your remains after that? So who do you want them returned to? There are lots of other ideas. I've cheekily named this other fun ideas, but just to provide a little bit of levity to this part of it, you can be cremated, you can be buried, you can donate to other medical education programs. There's a body farm in one of the Carolinas where they study decomposition in all sorts of different situations. You can have your body donated there. You can be turned into a diamond. You can make yourself a mushroom suit and compost yourself. You can become glass. You can be launched into outer space, which is what Susan said she wants to do. You can float away in a biodegradable balloon. You can grow into a tree. You can become coral reef. You can be turned into electricity. You can be cryogenically frozen. You can get plastinated, which is where your body is turned into sort of like a plastic. And you can, they did that body art exhibit. That's what they did to those bodies. You can get turned into fireworks. You can even be turned into a record of your favorite song. The man who invented the Frisbee was turned into 10,000 Frisbees. So also another option for you if you're looking for things to do. But again, all of these need to be written down. They need to be distributed so that your family knows. I love that somebody else knows where the body farm is. So thank you, Jonathan. I appreciate that. Okay, there are a lot of really great resources to help you in these conversations. They can be really difficult, and having support in these times is very important. You can call us. You can talk to me. We can go over all of these documents. I can point you to additional resources. You can download Mont Guides. They are amazing. If you haven't had a chance to go to one of Marsha's presentations, absolutely do that. She's so amazing, and she really makes these complicated and stressful conversations fun. She's great. So if you haven't had a chance to do that, definitely do it. You can look at Montana Law Help. They have a lot of forms. They have a lot of guidance. You can call the Montana State Bar Referral Service for an estate planning attorney in your area. This is especially true if you have custody of a minor child, or you have a minor child. If you have an adult child with special needs or a substance abuse or gambling addiction, really, really great ways, or those situations may require a trust, important to go ahead and look for a trust attorney. We can also make referrals for you, but you can call the State Bar directly. Okay, I think that's all. One other great resource is the 5 Wishes booklet. They have a great way to walk you through that conversations. There's also a really great the Conversation Project is a really great resource. They have guides to help you go through those conversations, both with yourself and with family members. And they have really cute little videos that'll help you decide what you want to do. So really good resources all around. If you don't know of one, if you're looking for one, happy to help you find them. So there's been lots of really great conversation in here. And I'm going to go ahead and stop sharing, and then folks can ask questions. You can unmute yourself. What do folks, are there more questions in here? I love that Karen, Nan, or Katie, whichever one of you, said that they are going to do it every Thanksgiving. That's a great way to break the ice and have that important conversation at a time of year that you know that you're going to be together. I love that idea. And it certainly would probably stop the talks of politics and religion if you're just going to be talking about estate planning.
Hi, Katie. My name's Jody.
Hi, Jody.
Hi, I work for Adult Protective Services, and I'm just curious if you know of any resources for clients that maybe are low income, that are unable to leave their homes, things like that, that might be interested in estate planning.
Sure. So if they are an adult with a disability or an adult over the age of 60, they can contact our program. We do phone clinics with folks, which are done over the phone, so folks don't have to leave their home. It's a completely free program. a really great way for people to be able to get those documents done. If they're under age 60, they can contact Montana Legal Services. They do some estate planning in limited situations.
Okay, good. And we refer to you a lot, but I wasn't sure if for estate planning, if that was something that could be done without actually meeting them. So that's good to know. Thank you.
Absolutely.
I've had to refer people to Katie quite a bit, and she's been very good with working with everybody I've referred to her over the last several years.
Thanks, Marcy. And I will send out this slideshow. I'll send it out right after the presentation, and you guys can have that. Absolutely. And we'll put the training up on YouTube as well as soon as we have it transcribed. Do we have any additional questions? You guys are letting me off pretty easy today, which I appreciate. Okay, well, if you think of anything, if you have a question, if you want to talk through a particularly difficult situation, always give us a call. Anything that I can't answer, Susan is always willing to help brainstorm. And our colleague Tammy, she loves the very strange cases. So anytime you have a weird question or something you haven't seen before, absolutely send it to us and we'd be happy to help. So. And then Susan will be doing her pitfalls of inadequate estate planning. It'll just be in hopefully in March. And my phone number, I'll put it in the chat now, but it's 444-7787. That's my direct line. You can send anyone to me. Did that actually go through? I think it did. And it's up on the screen, or it was up on the screen. So 406-444-7787. Yes. And yep, Montana Legal Services is really great too. Okay. All right. Thank you all. You will get the slideshow very shortly. And again, feel free to give Annalisa a call anytime you have questions.